on a construction site is not easy, and handling a construction site accident in the right way is not easy. It requires a lot of work, and I'd like to go through that in this brief blog. And it's an appropriate time for me to give a summary of the work that is necessitated, because this will be the 9th and final blog of my construction site accident blogs. First of all, your attorney needs a knowledge of the substantive area of law. In the bottom half of this pile is all having to do with Massachusetts case law, led by the important case of Corsetti v. Stone. It came around in 1985 and has really set the tone for responsibility of a general contractor at an accident site. The top half of this pile are exhibits in a recent case that I've been working on, and you can see how thick and voluminous this is. But it goes to far beyond just a knowledge of the substantive law, the knowledge of this Corsetti case and all the cases that have come after Corsetti in the last 32 years. It involves understanding the kind of work that was done at the construction site. It involves working with experts who will tell you what is expected and what is good practice on the part of a general contractor, who typically is the entity that is being sued. It involves a knowledge of contracts, and that contract, the American Institute of Architects contract, that imposes upon a general contractor or someone else who the general contractor designates the duty of safety. It also involves understanding corporations, because entities that buy buildings and renovate buildings may want the insulation, the protection of the corporate form. It involves understanding how to depose a corporation in that rule of civil procedure I spoke of under Rule 30b-6. It involves understanding of codes, the Commonwealth of Massachusetts regulations and the OSHA codes. And it involves knowing how to use them in terms of evidence. And speaking of evidence, it also involves knowing if any of the entities have been cited by OSHA before. And that will involve using that fact, not to prove that they violated something in this instance, although you want that proved, but to prove that the defendant had notice and could have gotten its act together. It could have been alert to the fact that they had violated this sort of thing before your client was injured. It involves knowing what constitutes an admission. It involves knowing what constitutes evidence of negligence, such as a violation of a company's own safety manual. So when you start, this is just an overview, and when you start listing them, you can see the breadth, and I will tell you there's depth to each of those to understand. And if you've been injured at a construction site, you need a lawyer who is willing to take that on and willing to work on your behalf from A to Z. Thank you.